You could come from a royal family, be a Raja or a Nawab, but you cannot use words like Raja or Nawab or even Rajkumar or Maharaja before your names in public. The Rajasthan High Court said this in a judgment recently, but why doesn't the High Court want these prefixes to be shown off? I'll tell you about this in today's episode of KYC or Know Your Constitution. Now, to explain this, let us go back in history. At the time of independence, we had 555 princely states covering 48% of the territory of undivided India. Under the Indian Independence Act 1947, each ruler had the option of either acceding to the dominion of India or Pakistan or continuing as an independent state. But it was the Herculean effort of VP Menon and Sardar Patel that persuaded the rulers to sign instruments of accession or instruments of merger to join India. And in return for surrendering their powers, the constitution guaranteed these rulers, these families, a tax-free privy purse, which was approximately 1/4 of what they had earned. In simpler terms, what this meant was that a privy purse was a payment made to the ruling families, royal or lower other families of former princely states as a part of their agreements to integrate with India and merge their states with the country. They basically lost all their ruling rights while agreeing to do this. And if you're wondering how much money these families were paid, the amount of these privy purses depended on the state revenue, the gun salutes it was entitled to, etc. So such payments were tax-free and were guaranteed under Article 291 of the Constitution. This yearly amount could range from anywhere between 5,000 rupees to 26 lakh rupees per year, which is a lot when you come to think of it for that time. States such as Mysore had got 26 lakhs, Hyderabad 20 lakhs, Travancore 18 lakhs, Jaipur 18 lakhs and Patiala 17 lakhs. These were among the highest recipients, while several smaller states got amounts as low as 5,000 per year as well. But these privy purses were abolished in 1971 by then Prime Minister Indira Gandhi through the 26th Constitutional Amendment. Gandhi made a case for abolition of privy purses based on equal rights for all citizens and the need to reduce the government's revenue deficit as well. Why am I telling you this story is simply because when these privy purses were abolished in 1971, Article 363A was added to the Constitution. This article says that whoever was recognized as a prince or a chief or a ruler of any Indian state would not be recognized like that anymore. And it abolished payment of that amount, which was guaranteed as privy purses earlier as well. So the Rajasthan High Court judgment now is basically more of a reiteration of this stance. Basically, a petition was filed in the High Court, and in January this year, it noticed that the name of one of the parties in that petition was Raja Lakshman Singh. So the court issued notice to the central and state government asking if people can still use words like Raja as a prefix to their names after the 1971 amendment. The High Court then issued a judgment recently saying that this can't be done anymore in public offices, constitutional courts or in public domain. And for this, it cited Article 363A, which I told you about, along with Articles 14 and 18. Article 14 guarantees equality before law and says that states shall not deny any person equality before law or equal protection of law. Article 18, on the other hand, abolishes titles. It says that the government can only give military or academic titles, and with this the High Court reminded everyone that such titles cannot be used in constitutional courts or public domain or even in public documents anymore. That's all I have for you today. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.